for that company, so we don't have the second accused. Yes. So it's clear count 1, not guilty, count 2.
On count number 2, you've been charged with obtaining goods by false pretenses, contrary to section 313 of the Penal Code. Particulars of the offense are on the 14th of March 2022 at Vutaride Limited, office in Westland area within Nairobi in the Republic of Kenya, jointly with others not before court, with intent to defraud, obtained goods mainly 500 liters of Farmitol, 2 SE, worth Kenya shillings 8,250,000 from Impala Rail Company Limited, by falsely pretending that you are a genuine supply contract, that it was a genuine supply contract, as fact you to be false. Is this true or not true?
Yes,
so the state is supposed to pay in the money.
In that case, then I have to allocate it so that I place it before court, which will be able to hear that. So you intend to post bail?
Yes.
Before the magistrate for bail application and further directions. If she cannot, then she could hear you tomorrow. The alternative is that I place you there tomorrow.
When I prepare to press that today, because this time most of us have closed their funds. Yeah.
And actually, when the fact that the accused was arrested on Monday, he has spent the entire period in detention and only being presented in court today.
It's okay, whatever it is, just let him appear before that court. Please give them the file, so that as to hear, they can give directions on that. The other file for mention, it's just a mention, and it's not supposed to be mentioned before me.
Yes, 1168.
And I believe it's a state which has justified to be placed before you.
For what
Just for the state to
2 of page 24 to defer plea. He gave the court the reasons for deferment of that plea. And we further prayed that the accused persons be granted cash bail. The court, upon hearing the parties, granted cash bail of 400,000. And on that given date, the court directed that its ruling was supposed to be delivered the following day. The accused person before you today had not been summoned, invited by the state or the investigative officer to appear in court on that day. It was a fresh matter which was just abandoned. An arrest warrant was issued. And indeed, I was present in court. I did inform the accused person of the warrants issued by the court. We appeared before the court on a different date to lift those warrants to the accused persons. The record of the court proceedings can bear me witness. And the driver, now Benmark, lifted the arrest warrants.
You appeared in this file?
Yes.
On which date?
it must have been. December.
And the magistrate lifted the warrant.
The court lifted the arrest warrants and further directed that the file should be May 5. Your Honor, the state had made an appeal on the ruling of the court and supplied the court with the ruling and the charge sheet.
Like the court's decision lifting the warrant of arrest.
No. They made an appeal in regard to the deferment of the plea in that matter.
Can I be supplied with the documents which have been handed to the court? Because otherwise that's an ambush. I'll not be able to respond to those issues.
The court, upon hearing the appeal made by the state,
Please supply, as you give me, also give the prosecution. So the state appealed against the court's order deferring plea.
and by that appeal, the High Court stayed the proceedings in the lower court matters. Indeed, these matters came before Court 5, on the 13th of December, and they were mentioned before Court 6, because the court wasn't sitting that day. And the same position was made that the High Court had stayed the lower court proceedings pending hearing and determination of the appeal lodged by the state. Your Honor, the state having obtained stay of the proceedings in the lower court matters, the accused person made an application to the High Court to be released on anticipatory bail. And the High Court issued an order to that effect. Your Honor, it is humble submissions that since the proceedings in these matters were stayed and the entire matters are seized over by the High Court, and there's a ruling in place for your brother staying or deferring plea in these matters, we pray that the same be maintained. Your Honor, criminal case number 11E1168 was a reactionary suit filed.
Criminal case number
1168 was a reactionary suit filed by the state after conceding defeat in 1162 that the charge sheet was defective, thus filed 1168 to try
They are conceding defeat in which file?
that in 1162 of 2024
That the charge sheet
was
was defective.
defective, thus brought 1168 of 2022 to cure the charge sheet of 1162.
1168
Yes,
was meant to cure
yes,
the defect in 1162.
yes. You will now supply the court with the copies of the charge sheet of both files. They are a copy paste of each other, word by word, full stop by full stop, police file by police file. The difference there is the parties, the particulars are the same.
You are saying they are identical.
They are identical. Your Honor, we pray that we maintain the status quo as per the ruling of your brother in Mark and the High Court orders issued in the application made by the state in which they tend to appeal the decision of the lower court. The lower court, the High Court matter has got a date of 22nd January. It also appeared before court last week, and the court gave further date of 22nd January for hearing all the pending applications. In that regard, Your Honor, I pray that we defer this plea as per the
Of these proceedings, or rather they are not aware of their orders. But Your Honor, if you were to look at the record of the court on the 4th of December 2024, and even before then, when they say arrest warrants which are being effected today were issued, or rather suspended, the prosecution was in court. But at the same time, they wish to indicate to you that they are not aware of the proceedings of the same file, that they are indicating, they are effecting warrants. What you are being asked to do today to proceed with the issue of plea taking is that the prosecution is asking the court itself to warrant them with the continuance of a contempt of the court's orders.
File.
Yes, yes, it has been confiscated in this file, 1168.
Why don't we go one item at a time?
Yes.
We are right now on the issue of whether plea should be taken or not.
Okay.
Yeah, why don't we finish up with that? Because the rest may not even be within this court.
Oh, that is there, thank you.
For me, you brought picture of the documents.
I've only received 2 documents, but I'll proceed nevertheless.
Your Honor, if I may, on the issue of supply of documents, I've given court charge sheets, which are the police file which council is having there. So I don't need to supply.
1168,
Yes, and 1168. Then 2,
1162.
which council has that 5.
There's a ruling.
Yes, there's a ruling. He
Yeah,
has a
yes,
copy.
1162.
Yes, he has a copy.
What else?
I have a ruling in 1160.
I have the orders of the High Court where he made his own appeal.
Or have the High Court, do I
Yes.
have them?
Yes, we can proceed.
Yes, I've supplied the app there and the diary. So the state the position of the
In this matter is that so it's an attempt by the accused person to mislead the court by globally submitting on all the matters he's facing before Milimani. The reason before why the state is saying this is that submissions have been brought to you about a matter number 1162 of 2024, in which you have been supplied the charge sheet. The accused person,
Just a minute. Nobody submitting on all matters.
they are globally submitting on all the matters facing the accused person in these courts and not concentrating on the matter before you, which is distinct from all the other matters the state has filed against the accused person. Then I'll start by submitting with regards to file number 1162 of 2024. Your Honor, the accused person, we have the charge sheet, which was registered on 19th November this year. The accused person in that matter is one Halima Samson Mwangela.
Was registered on
19th November 2024.
the accused.
Is Halima Samson Mwangela and not the accused person before court. The court has been misled to believe that the accused before court is one Halima Samson Mwangela. And by the sound of that name, you can tell it's a lady's name and not an accused individual. And Your Honor, upon the accused person being presented before court, she rushed to the High Court by criminal revision number E1729 of 2024.
That is Halima.
Yes, Halima Samson Mwangela. E1729.
That's a miscellaneous.
It's criminal revision.
Right. High court.
High Court revision
Revision number.
E1729 of 2024. And that is the order you have been supplied with, telling you that it has stated the matter, including the accused person's matter. And what has been stated is only Halima Samson's Mwangela's matter, which is coming up on the 22nd of January. It's coming up on the 22nd January 2025, according to the order issued by the High Court dated 9th of December 2025. And Your Honor, Halima's matter is the matter which the state had also moved to the High Court. Dissatisfied with the ruling deferring moved to the High Court, and eventually the High Court has stayed the matter. We submit that even if the accused person was a relative of the said Halima Samson Mwangela, the orders staying this matter do not extend to him. They are impersonal. Thus, Your Honor, our submissions is that as we appear before you this afternoon, there are no stay orders in 1162 barring this court to charge the accused person or to deal with the matter dealing with the accused person. Then I'll now move on to the next file, which is the one now that is before you.
The file number?
1168 of 2024. Where the accused person, we have presented a charge sheet where the accused person is the first accused. There is another accused person by the name of Maureen Mudhoni Mwangela, who is not before court. Your Honor, that matter was presented on the 20th of November 2024. For plea taking. Not reactionary to the file number 1162 failing, as has been submitted, but because there were two other accused persons, fresh accused persons who the state wished to charge. Your Honor, on that material day, both accused persons were absent. That is on the 20th of November, before your brother in court number 11. Your Honor, warrants were issued and the matter was set down for mention on the 4th of December to confirm arrest of the two accused persons. However, Your Honor, the accused persons made an application on 2nd December before court number 5, seeking a lifting of the warrants. And it is notable from the record of the court, Your Honor, that the warrants were not lifted. What the court did was suspend the warrants. The warrants are still in force, but suspended. The court was even misled in that matter and informed that there is a similar matter coming up on 4th of December. And that the accused person will present themselves in that matter for further orders. That was the reason the warrant was suspended. Subsequently, Your Honor, the matter was mentioned on 5th December. And accused number 1 was said to be unwell by the counsel who was in court, Mr. J. Kamau.
So subsequently, the matter was mentioned on
5th December. Where the accused person was said to be unwell. First accused person was said to be unwell. The second accused person did not appear. The first accused person to counsel presented a medical note dated 3rd December. Which indicated that the accused person had been granted 4 days sick leave from the 3rd of December to 6th December.
that's the case, and you granted what?
From the medical notes, it says he has a sick leave from 3rd of December to 6th December. And he was going for further review on 9th December. And thus the court fixed the matter for mention on 13th of December. Where none of the accused persons appeared. Counsel for the first accused person informed court that the first accused person was still unwell. There was no medical note which was presented.